Inside America's Boardrooms, the informational show for board members and corporate secretaries. Brought to you with knowledge partners NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini, Goodrich, and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this edition of Inside America's Boardrooms. I'm TK Kerstetter, the CEO of Boardroom Resources, and your host for today's show. We're going to be talking about current legal issues, and with me is Bill Chandler, who is the former Chancellor of the Delaware Court of Chancery and a current partner with Wilson Sonsini, Goodrich, and Rosati, and most importantly is our legal expert here on Inside America's Boardrooms. So Bill, welcome back.
Thank you, TK. Good to be back.
So I think it's been probably 6 months since you were here last, so it's a good period of time. And I guess my first question is, what are the current issues that that have legal ramifications that board members should be aware of?
Well, I think your audience is going to recognize some of them, TK, I'll list them fairly quickly and sort of tick off what I think are the legal implications of those issues, which, as I said, I think your directors are already familiar with. One would be shareholder activism. And I'm not thinking really about the things that companies and boards need to be doing to be proactive about addressing the issues through shareholder engagement and so on, so as to avoid an activist issue. I'm thinking more about the legal implications of activism, and that's where the board needs, I think, to have their advisors, their legal advisors, looking carefully at the company's defensive profile. By that I mean looking at things such as, do shareholders have the right to take action by written consent? Do shareholders, or some percentage of shareholders, have the right to call special meetings? Does the company have, what kind of advance notice bylaw does the company have that would require shareholders who want to take particular action, such as nominating a new director or putting a proposal before the board, to give the company and the board advance notice that they're going to do that? So I think there's an emphasis on making sure those defensive measures that a company might be protected by have been looked at carefully to be sure there are no flaws or no gaps or no way that they could be avoided or in some way circumvented. So that's on the sort of activism issue. The other issue I think that boards are very familiar with and should be conscious of is the cybersecurity risk. And I'm not talking there about all of the ways in which they try to avoid that risk for the company. I'm talking more about the potential liability risks to the board if there were to be a cybersecurity breach or a data breach that caused some risk of harm to the company. They need to be thinking about a record that shows they have a system in place that was designed to prevent that from happening, and that it was a system that had a very robust reporting requirement, reporting up to the board, and that's all well documented so that the board can defend itself in the event there was a data breach or a security breach. They'd be able to show to a court, because there will be the inevitable litigation, what's known as derivative litigation, saying that the board did not properly oversee the risks that the company was faced with. So I think they should be very conscious of that reporting system and of the system to ferret out and protect against those risks. A couple of other quick issues I'd mention that have legal implications are if the company in question has a controlling shareholder. There was a recent decision out of Delaware that said it's going to be very difficult if a controlling shareholder has received some type of non-ratable benefit. By that I mean a benefit that the other shareholders don't receive or don't benefit from. That's going to be a very difficult case to get out of early, and that you're going to be in for the long fight, fighting through what's called entire fairness and showing that what the board did was fair in terms of price and process. I think that case recently said the only way you can escape that is if you have a special committee of independent and disinterested directors to approve that benefit that the controller got, and you have the unaffiliated shareholders of the company vote that it's approved and okay. Very difficult thing for most companies to do.
It's a high bar.
And the final thing is director compensation. Directors need to be aware that there's been a flurry of recent cases in Delaware in particular, challenging director compensation plans. You need to be vigilant about the legal issues here, showing a proper process was followed, that you had consultants, that you fell within your peer group, let's say, but more importantly, that you have a plan for any equity awards that are specific and that have received shareholder approval so that the directors aren't considered to have been in a self-interested or self-dealing situation. So that's sort of my 3 or 4 items that I think have some legal implications for directors.
So you mentioned the Delaware Court of Chancery, and I guess sometimes the Delaware Supreme Court. You mentioned director compensation and M&A. Anything else that, from your inside track, that might be coming down the pike in Delaware that directors should at least be aware of?
Well, I think there are. I mean, it was roughly a year ago, I think, TK, not 6 months. I think it was a year ago when I was here last.
Okay.
And I know then that the bubbling issue that I was talking about that had raised such a brouhaha in Delaware was about fee-shifting bylaws and the ability of companies to shift attorneys' fees in the event they're involved in internal litigation. And that issue was pretty much put to rest by the Delaware legislature. They came down on the side of saying absolutely not, that companies cannot adopt bylaws that shift fees in that manner. And so they've sort of closed off that avenue of trying to balance the scale here a bit. But I think the other interesting issue that since then has sort of bubbled up and that is going to be considered and I think probably adopted between now and June 30th by the Delaware legislature is something that deals with what's called appraisal arbitrage. That's where companies buy shares of a company that's thinking about a merger, even after the merger may have been announced, and then complain that the merger price was unfair and doesn't reflect the true value of the shares of the company, and they file an appraisal action in the Court of Chancery. This has gotten a lot of attention, and I think Delaware is going to try to address it in part by this statute that's being debated now that will make requirements that those shareholders hold at least $1 million in value of the shares, and secondly, that they can't trade on the interest rate, that there's interest paid on that appraisal award while the case is pending, which could add up to millions of dollars. Now the company is going to be able to pay that money to the shareholder and avoid the interest from accumulating during the course of the litigation, which I think will reduce the amount, at least somewhat, of these appraisal arbitrage opportunities. That's one thing. The other thing I think that's important in the Delaware courts that's happened is the forum selection bylaw has now been validated not only in Delaware but across the country. So companies can choose the forum, the state where they want to litigate for internal corporate disputes, and that's going to be upheld. Now the unknown question is, and I think this is we'll have to wait for this to be decided, can companies that have chosen a particular forum, if they've chosen Delaware or they've chosen North Carolina, if they're a North Carolina corporation, can they waive that and allow a lawsuit to go forward in some other jurisdiction where they might be headquartered, let's say, because they think it's preferable to have the lawsuit litigated there rather than in the chosen forum? That's sort of an unknown question that I think we'll have to wait and see what the answer or the verdict is on that. But it's a very topical issue right now amongst the legal community. And finally, there's the advisor conflict issue. You know, when companies hire investment banks or financial advisors, there's a lot of litigation right now, and directors need to be aware of it, about whether those advisors have conflicts, whether they might own shares, for example, in the counterparty that's being negotiated with, or have they done work for that counterparty in the past and therefore might have divided loyalties. Directors need to be very careful in vetting their financial advisors to be sure there are none of these conflicts that could result in later litigation.
So, Bill, we'll just have to watch what happens in the Delaware courts and see, again, have you back and see which of those has taken, either been stopped or continue to be a fact. My last question for you is a little, sort of gets to your experience versus your legal experience, and that is, what is, if I asked you what the biggest mistake that you see boards making today that sort of creates an ongoing legal problem, okay, what would you from your experience, what would you say that mistake is that you would identify in general that boards make that sort of is something that sort of gets them in a little bit of a jam?
It's a good question, TK, and you know, this answer is really driven by my experience over the past 5 years since I left the Court of Chancery and joined Wilson Sonsini. And I'd say, I think, sort of prefatory to what I'm going to answer your question with, I think boards get it right most of the time. And I think they really try very hard. All of my experience has been that they're really working very hard to do the right thing. And individual directors are trying their hardest to comply with all the requirements that they have to comply with through the federal rules and the state rules, and doing their very best to meet their fiduciary obligations to the company and its shareholders. So having said that, I think my intuition is, and my experience is, that while they're working very hard to try to do that, there are so many pressures on them. I worry that they can't do all that they need to do in terms of meeting the compliance requirements and also paying close attention to the strategic direction of the company and overseeing management in that strategic direction. But my advice to boards is to remember what judges are going to look at. Remain mindful of what it is judges are and what they do. Judges have very little or no business experience. They don't understand business, frankly. Judges don't have financial backgrounds. They don't have backgrounds in strategy. But what they do have a background in is what the law is all about, which is process and how decisions are made. And what is the process that the board went through in reaching a decision or in taking some action? And judges want to see a good process. And if they see a good process, they're going to be very respectful and deferential of that board. So if you have a board, particularly a board of independent and disinterested people who are making a decision and they can show that they went through a good process, whether it's in the M&A world when they're making an acquisition, let's say, or if it's in a compensation decision, for example, or if it's in some other arena, such as a books and records demand. Have they gone through a good process in trying to address that issue? And that always leads to the ultimate question. It's like the old adage, I don't know if you've ever heard it, people have said, if a tree falls in the forest and there's no one there to hear it, well, does it make a sound? So if a board follows a wonderful process but doesn't document it, will a judge still respect it? That's the question you don't really want to face as a corporate director. You want to have it documented, and that's where your corporate secretary, your general counsel, and others can make sure that this wonderful process that you've hopefully followed is documented, that there's records of it, that there's presentations that were made from your independent advisors, and that's all documented, that there are minutes of the meetings that reflect that you fully considered the issues and you asked good questions and questioned the answers, that you did all of that. Be careful about that record. I often tell directors, don't send stupid emails because there's this thing called discovery. You don't want discovery and finding emails where you say things that would be embarrassing or hurtful to you. So develop that record, but be careful of it. That's the biggest advice I'd give to boards, because I do think they're trying their very best to do a good job.
Well, you bring up a great point, and I think we're going to have to give some thought to doing a show just on proper minutes relative to that, because there has been a lot of discussion about be careful of what goes in the minutes. At the same time, we've seen a lot of cases where you need disclosure of what's happened, yet there's always been this rule, even notes that you jot down, you need to be careful with. So that might be, you may have identified an important topic that we might need to spend a little time on.
That might be its own show.
Right, right. So, Bill, I want to thank you again. It's always a pleasure when you take the time to come and bring us up to date on those issues. So I want to thank you again for joining us. And that will conclude this edition of Inside America's Boardrooms. We hope you enjoyed the show. We'll be back again next week when we take a look at another critical topic that'll help you be a better board member or committee member. So we'll see you then.
Join us again next week for Inside America's Boardrooms. Brought to you with Knowledge Partners, NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini, Goodrich, and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.